Welcome to Shelter House Shares on MCTV. Today we're going to talk about domestic violence and the courts. But first I'd like to welcome our guests, Ann Maneri and Mike Carpenter. Welcome.
Thank you.
Thank you.
I'm going to start with a few quick facts about domestic violence and define domestic violence. We know that 1 in 4 women will, at some point in their life, be affected by domestic violence. It happens in our community, it happens across the United States and around the world. So today we're going to try and talk about what happens in Midland County. From Shelter House perspective, we deal with intimate partner violence, which is a little different than what the law says, because in the law it deals with siblings and all different kinds of arenas. But we at Shelter House deal with intimate partner violence, which is an ongoing pattern of abusive behavior. It can be physical, it can be emotional, it can be verbal, it can be all controlling behaviors, financial, sexual, many, many arenas that we find that we have people come to us with those concerns. The other piece of it is the intensity and the chronicity. So if it happens a lot and it's pretty intense and ongoing. So those are all the factors that we look at when we're talking about domestic violence at Shelter House. So Mike, we'll start with you. Can you describe the role of the prosecutor's office when it comes to domestic violence?
Certainly. Thank you, Janine. And I appreciate the opportunity to be here today.
Thank you.
When cases are sent to our office, prosecution, they're sent by police. So there isn't a circumstance typically where an individual would contact our office directly.
Okay.
They call 911, or a neighbor in a lot of cases calls 911. Police report is done, they submit the paperwork over to our office, and then we make a charging decision as to whether or not we believe we can prove a case beyond a reasonable doubt, and we decide whether or not to charge, and if to charge, what to charge.
Yeah, we've had conversations where you've told me that, you know what, I think we can get something at a lesser charge, and those kinds of conversations.
Yeah, so as you well know, the difficulty with domestic violence is a lot of times it's learned behavior both ways, both on the aggressor's part and on the victim's part. And a lot of times the victims will deny that something happened, even after they may have told the police that it did. It's not unusual, unfortunately. A lot of times it's because typically it's the male who is the aggressor and the female who is the victim in the case, although it can be both ways.
Right.
But typically the male has the access to the finances, has a lot of control over the female, and we know that there's a lot of pressure put on the female to ask to have the case dismissed or reduced. The difficulty we have is, in order to prove a case beyond a reasonable doubt, I need a witness. And in some of these cases to where 911 is called, if the victim simply cannot remember accurately or decides that she's going to be reluctant in testifying, it's difficult for us to get a conviction. Most people who've not been a victim of domestic violence or been involved in it really don't understand why someone would get on the stand and say something didn't happen when they tell the police that it did.
Right.
And so it makes it difficult to gain a conviction, and at that point in time you're in a negotiation with the defense attorney to try to find something that you can get jurisdiction over the person so that you can order them to counseling, anger management, that type of thing.
Sure, sure. Thanks, Mike.
Yes.
Ann, what does the court clerk, well, how does their office intersect with domestic violence?
Well, we actually see a lot of people who come into our office that have not called the police. Probably they have gotten to a point in their relationship with this individual where they're very scared, but they don't want to get the police involved because they're scared of that too.
Okay.
So they will come to the clerk's office to request a personal protection order. And that is a product that they can fill out, and the judge looks at it to determine whether or not the judge believes that that person is in imminent harm. If the judge believes that, then a order is entered where then the perpetrator would not be able to have contact with the victim. That means they can't live in the house, they have to move. Again, the money situation comes into play. We do unfortunately see a lot of people who come in and get a personal protection order, and then a week later they're back in asking to have it removed because they have no money, they have no way to be able to support the children that typically are in the household. So it's a cycle. It just keeps repeating itself. But that's what they would do. They would come into our office to request the personal protection order.
Okay. Well, we'll go to that more in depth in just a minute, but let's talk about what happens after the arrest is made. I know often that there's a no contact order. You just talked a little bit about a personal protection order. So when the no contact order is issued, Mike, can you tell us what is a no contact order, and then we'll go into how that might differ from a personal protection order?
Certainly. Judges speak through orders, and so until a judge orders you to do something and orders you not to do something, there's no power of the courts that are keeping you from having contact with an individual. So, in instance, if there's a domestic violence, let's say that a boyfriend and girlfriend are in a dispute that ends up being physical, and the male is arrested. A police report would be generated, sent to our office. We'd make a charging decision, in this case, charging the individual with domestic violence. And then we would request that the judge tell the male not to have contact with the female. What Ann was just talking about is a personal protection order. That's the individual. That would be the female asking for the order to protect herself. Okay. In this case, we're asking it, so it's a different type of order. It's an order that's attached to a criminal case. So in this particular case, we have to have some kind of mechanism, or in this case, criminal charges, that a judge can then put the order inside that case. And is essentially a lawsuit of one person against another person, to kind of oversimplify.
Okay, so a personal protection order does not have to have criminal charges filed.
That's correct, and as Ann indicated correctly, a lot of times they won't call the police, but they may seek a personal protection order because they feel somehow that that's less intrusive and not as harmful to the other individual. It's just an order saying, tell me to stay away. In this particular case, there'll be criminal charges attached to it and an order telling them to stay away.
So the victim can't come in and say, take that away?
They can, and they do.
Well, okay, what
happens They do frequently.
Then?
Well, they request from our office if we would be willing to have them remove the personal, or what they call no contact order. Mm-hmm. That time, because under the Crime Victim Rights Act, which is something that our office has to adhere by, we're to listen to the victim, even if we think maybe it's not in their best interest, mm-hmm. and we would present and allow them to do an affidavit as to why they think they could have contact. They would then put that document in front of the judge. However, because we represent both the victim and the state of Michigan, we can provide that affidavit which says, I want to have contact and here's why, and then we personally then say we object to the contact, and then the judge then makes the decision as to what he or she may do.
Okay. So could the judge conceivably say, there's still no contact, but in these instances you may allow contact, like you may
for counseling purposes,
for
things
whatever.
of that
so it
nature.
can be
it can be modified.
Yes, and Ann would see more of those orders for those no contact. So it could be to pick up and drop off children only. It can be for counseling. She would know much more about what those terms are because she manages those documents that the judge makes the orders.
Is that true for personal protection orders, that they can be personalized?
Yes, they can be modified for limited contact. Typically when someone comes in to get a personal protection order, they don't want to have any contact with that person at all. No email, no text messaging, no phone calls, no face-to-face conversations. However, as their cases progress, they will find a need to have some kind of contact, especially if there are children.
Okay.
They have to be able to communicate with one another, pick up and drop off, and those sorts of things. So we can modify personal protection orders, but anytime you request to have a personal protection order either dismissed or modified, it has to go in front of the judge. And the judge listens to both parties and determines what's in the best interest of those parties at that time.
Okay. So talking about the personal protection orders, can you explain to us the process? How does someone go about obtaining? They walk in your office and then?
They would present themselves at the circuit court clerk's office at the courthouse and request a personal protection order. And at that point in time, we would ask them the relationship to the person they want to have restrained from them. Probably 90% of our personal protection orders are domestic, so that means that they had a relationship or they lived in the same house. And so at that point in time, we give them the forms that they will need to fill out, and we explain to them that they need to write out a statement. The statement is the most important part of any personal protection order because that gives the court a clear picture of what's been going on that makes that person feel threatened, stalked, harassed, or in fear for their life.
So they need to make a full case.
They need to make right. You know, at one point in time, everything was wonderful, and then all of a sudden, all these things started to happen. We also recommend that if they've had police contact, that they put that into the personal protection order so that the court is aware of that. And then ultimately it goes to the judge, and the judge reviews each of the personal protection orders to determine whether or not they should be issued.
You had said that things used to be wonderful and perfect, and now they've changed. And I've heard in the trainings I've been at, the judge really wants to hear why now, what's different.
Yes. We try to explain to people that anyone can certainly come in and ask for a personal protection order, okay? But we want to make sure that if there's a pattern, we want to draw that out. So we try to say to them, has there been more than one instance where this person has done things? And it doesn't have to be physical. I mean, it can certainly be verbal. It can be emotional. It can be financial. I mean, a lot of times we'll have women come in and say, he's verbally abusive and he won't give me any money. I can't go to the grocery store or buy groceries for the children. So, I mean, there's lots of different things wrapped up into each and every one, and everyone is a little different. We do have people who will come in and get PPOs that probably don't need them, and that's when the court steps in and says, I don't see a need for this at this time, and they will deny that request.
So there's two kinds of ways that the court intervenes to protect victims, the personal protection order and the no contact. And I think you've done a really good job of explaining the difference, so thank you for that. We know that there's a lot of barriers for people in domestic violence situations being able to come to terms with, to face all that they're going to have to go through the court system. To decide what to do. Sometimes, like you said, it's the children, sometimes it's the money, sometimes it's fear, a lot of different reasons why people may hesitate to seek the court's help. So what are either some real or perceived barriers for people coming to the court from your perspective?
Well, one is the culture and where they've grown up. As I kind of mentioned before, a lot of these are learned behaviors. It's something that it's generational, unfortunately. You have generations of people who are abusive, and you have generations of people, unfortunately, who have been victims of abuse. So a lot of times the barriers, they don't know any different. They anticipate that that's something that's normal, and if that's all you've ever known, you wouldn't know what's happening to you is not normal. The other is fear, fear of the unknown, fear of what to do regarding finances and how you're going to make ends meet, because in a lot of times, that one of the control things that you're using is finances, and so if the female's dependent completely on the male for all of the money for food, rent, clothing, she quickly, once he gets arrested, she's reminded, either by him or maybe family members, what are you going to do to be able to support the children? Other times, she may be working out of the home, but they have no other daycare except for the father of the children or the domestic partner. So you have those barriers. Sometimes you have distrust of police. On occasion, the victims also have some point in time have maybe been involved in the criminal justice system in some way, shape, or form. Could be maybe something involving like a retail fraud or stealing, or maybe drinking. And so they feel as if one time if I made a mistake that I won't be believed, and so they won't use the criminal justice system because they're concerned that they may be labeled in some way. Others is that they just simply are used to the circumstance and have second thoughts and decide that I don't want any part of that.
And one of the things that we try to do, at least in our office, is make sure that if it is a domestic situation where they are still living in the same household, is to make sure that she has a safe place to be. So whether that be with a family member or even contacting the shelter. We have shelter cards right on the counter that we give out on a regular basis, and try to explain to them that this isn't the end all, that you can live without this abuse in your life, and these are some of the steps you can take to do that. So we do try to advocate for the shelter and for the programs that you have available for individuals who are victims.